Muted. Ellen, take it away.
Take it away. We have with us today one of my favorite presenters. I think she was, all of the presenters are absolutely wonderful in this course, but I think Meredith was candidly the star last year, and I think she'll probably be the star again.
Merritt.
She has had a promotion since she was a presenter last year, and she is now, what, an associate professor of law, Meredith?
I am, yes, an associate.
Yeah, she's moved, she's climbing the ranks, so other people have recognized her incredible skills. Before we start today, I want to say a couple of things. At the beginning of this course, and this is the last session, I said the two major issues for the Supreme Court now and then the next term are going to be abortion and guns. And I don't think I've been proved wrong if you've been following the news. Meredith, of course, today is going to talk about guns. And her presentation is incredibly timely because the Second Circuit is dealing with some questions now about the New York gun laws. They're dealing with whether or not you can carry a concealed gun outside of your home or place of haven, whatever you want to call it, for alleged self-protection. So they're dealing with a major case right now, and there are going to be other major cases like it. It's going to have impacts on all the other states, just like the first Second Amendment case did, which unfortunately I was a part of it. And I begged our Attorney General at that time not to take it to the Supreme Court because we all knew what was going to happen and the impacts it was going to have on other states. And of course it did. And the Second Amendment case currently before the court, which involves the New York state gun law in terms of concealed weapons, is going to have that same impact. The other thing I want to bring to your attention is we talked a lot about abortion in this course, and the Supreme Court, I think on Monday of this week, expressed a lot of skepticism about the Texas law and this 6-week abortion ban. It appears ready to allow abortion providers to challenge the law in federal court. It's not dealing, the case does not deal directly with the ban's lawfulness. Rather, the justices are sort of wrestling, I would say, with whether the Department of Justice and abortion providers can bring federal lawsuits against Texas or state officials in an effort to block the law. So I just wanted to bring that to your attention. That's moving along, and the Supreme Court seems to be ready to allow abortion challenges to challenge that law because of the 6-week abortion ban. And Meredith's not going to talk about that case, but I wanted to bring that to your attention because we did spend a lot of time talking about the abortion cases and where they were going and what was likely to happen. So I just wanted to bring you up to date. And with that introduction, I'm going to turn this over to Meredith.
Great, thank you, Ellen. I'm happy to be here again. I appreciate the generous introduction, and this was a lot of fun last year. So I look forward to the conversation this year. And I'm sorry I missed some of the discussion of the abortion cases because those are really interesting to me, especially the ones that were just argued. There's all these really complicated procedural problems that bore lay folks, but lawyers love. In fact, I'm thinking of teaching some of my class next semester, sort of focusing on some of the litigation challenges in that case. It nothing to do with the merits, but just the challenges of the unusual law that's at issue. But in any event, today we're talking about guns. So what I'd like to do, and I have some slides to share, but my plan is to sort of just to give you just mostly background about the Second Amendment, how we sort of got to where we are, some of the major cases, what's before the Supreme Court now. They heard argument this morning, so it couldn't be more timely. I'll offer some predictions, although these things are one's always cautious about predicting what the court does. Sometimes we get that wrong. Even computers get it wrong when they try to predict what the court does empirically. But at least some things to look for, and some of the ways in which the current litigation could shape how we look at gun rights going forward as a matter of the Constitution. And I want to say from the outset that the Second Amendment does a lot of sort of rhetorical work in our lives, right? We think about the right to keep and bear arms sort of rhetorically, but a lot of states protect the rights even more robustly as a matter of state statutory laws and state constitutional laws than even the federal, Second Amendment rights. So depending on where we live, the Second Amendment does not have a whole lot of work to do, but it has real power, I think, rhetorically as part of this debate. So that's something to keep in mind. The case that we're going to be talking about, it certainly will have significant effects in that states, because we have some states that have much more restrictive gun laws than in other states. So let's start with just the Second Amendment and talk about what the Second Amendment means, how the Supreme Court has interpreted over time. And the Second Amendment is, it's sort of this is, for those of us who like sort of constitutional law, this is a really sort of constitutional law nerdy thing, because it's a lot about the text of the amendment, what that means, what it's meant historically. In fact, I began my constitutional law class with the case that we're going to talk about, which is the Heller case from the Supreme Court that Ellen mentioned in her opening remarks. So I actually began constitutional law by talking about the Second Amendment, because it is a wonderful example of how the Supreme Court, in particular, the modern Supreme Court, does constitutional interpretation. And so we're going to spend a little bit of time on just sort of constitutional interpretation and what that looks like. And as with many sort of efforts to decide what the law is and what it means, we begin with the text itself. And so here is the text of the Second Amendment. This is all it says: a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. It's got a lot of commas. It's not all that clear, right? It's not even a particularly great sentence. And that's all we have, right, to start these conversations. And historically, there have been, I would say, sort of two views and competing schools of thought about what this relatively poorly written, in my view, sentence means. And one I will call, for shorthand, the structural view, and I'll explain what I mean by that in a minute. And the other, the individual rights view. I think the individual rights view is probably going to be self-evident here, but let me explain the structural view. The structural view emphasizes that first clause, talking about the militia. And it understands the right of the people to keep and bear arms as being a part of the ability of states to have militias. And that really the thrust of the amendment is about protecting the ability of the individuals to participate in militia service, and so that the federal government can't disarm state militias. That's really what the founders were worried about. And that's why we have that, the militias being important, it's giving a lot of emphasis to that initial clause. The other view, on the other hand, is the individual view, which would find, at the very least, and we can talk about, there's sort of a range of how exactly broadly we interpreted it, but some kind of personal individual right to possess a gun for self-defense, at the very least in the home. And the current case is kind of testing the boundaries of that idea. So one way we look at it is really about states' rights and about the relationship between state governments and federal governments. And that's partly because the Bill of Rights originally, we get the Bill of Rights in the Constitution as a sort of states' rights effort. We were worried about this big federal government that was going to infringe on both the states and these rights that the founders thought were fundamental, that weren't spelled out in the Constitution. But all these other sort of expansive powers were given to the federal government, and there was a worry that there wasn't a sort of mechanism to protect rights that either belonged or were sort of resided in the states historically, or belonged to us sort of fundamentally as citizens. And so both are happening in the Bill of Rights. Some of the provisions are sort of clearly about protecting states, and some of them are more about individuals. But if we go back to sort of our language, if we go back to the Second Amendment, we see sort of both of these things at play in the language itself. So the textual arguments and the historical arguments really sort of focus on different aspects of the language. How much do we emphasize the militia clause versus how much do we emphasize what's ultimately called the operative clause, the right of the people to keep and bear arms? And how do we read them as, do we read the first clause as limiting the scope of the second, or is just kind of like an example of why it's important that the people have the right to keep and bear arms? So let's look at the language again. And I want to compare it as well to some of the other language that was sort of in the ether at the time that was used to protect the rights to keep and bear arms at the state level. So a well-regulated militia, being necessary to the security of a free state, that seems like, if we're just sort of reading it as lay people, that seems like it's about like explaining why it's important that we have a militia, right? It's necessary to the security of a free state. We also have the idea that the militia can be well-regulated. What does that mean? It suggests, at least at the outset, that the militia itself is subject to some limitations by the government, right? It is well-regulated. It's not just a militia being necessary to the security of a free state. And then the right of the people to keep and bear arms shall not be infringed. Now, the right of the people, there's some debate about whether that means, is it collectively, like the people all together, we collectively have this right? Or does it mean that the people sort of individually have a right? And that was part of the debate too, as to whether or not the people means sort of a collective body as opposed to an individual person having this particular right to keep and bear an arm. We also get this language, shall not be infringed. That sounds really strong, right? Like the government can't do anything, right? If a right shall not be infringed, that sounds like the government has to keep its hands off. Now that's in some contrast with the idea that a well-regulated militia, when we think of regulation, we think of the government regulating us, is important. So compare that kind of language to language that's found, for example, in the Vermont Declaration of Rights, which is a contemporaneous document to the federal Constitution. There, the language is, the people have a right to bear arms for the defense of themselves and the state. If you were drafting a provision that gave an individual right to a person to have an arm in self-defense, the Vermont example seems like a better way to accomplish that, right? It's much clearer. It spells out exactly the right. It reflects both this idea of self-defense as well as an idea of the militia service. So the debate again is over, is the militia language limitative? Does it limit the reach of what comes later? Or is it merely an example of why the right is important? One asks one way in which the right to keep and bear arms becomes important, but not the only way, right? If we sort of all have the right to keep and bear arms, and that facilitates both self-defense and defense of the state, that's not necessarily at odds with the language that's in the Second Amendment. There's a more direct way to say that, but it's not necessarily contradicted by the language in the Second Amendment. So before we get to the Heller case in 2008, which is the sort of the major case that that decides the core question about which view of these is right or wrong, there was not a lot of litigation on the Second Amendment. It didn't come up a lot. You know, for a variety of reasons, there was just very little. The most significant Supreme Court case before 2008 was this case called United States against Miller. It's from 1939. It was an individual who was being prosecuted for having a sawed-off shotgun, which had been made illegal by federal law. And he raised a Second Amendment defense that he had a right to possess this sawed-off shotgun. And the court, in its decision, it's not a very clear decision. It's not all that well written, but it seems to endorse a view of the Second Amendment that suggests that the militia language is really important and that the Second Amendment doesn't protect some individual right to possess a sawed-off shotgun. Now, it can also be read, arguably, to suggest that really just sawed-off shotguns aren't protected by the Second Amendment. So the type of arm wasn't covered because it wouldn't have been the kind of thing that you use in a militia anyway. But most of the courts after Miller, all the lower federal courts, had taken the somewhat unclear language from the Miller case, but the thrust of it to suggest that the militia view was the right view, as opposed to the individual rights view. So from 1939 until we get to the 2000s, that was settled law across all the federal circuits, and it wasn't all that controversial. And at the same time, sort of beginning with the gun rights efforts and sort of the reinvigoration of that in the 60s and the 70s, a lot of those efforts were focused at state level reforms and state level protections. The federal question was largely thought to be settled. That is until the Heller litigation. And this is a litigation that targeted the District of Columbia's laws that were on the books at the time. This was a law from the 1970s. And it was very restrictive in the district. The district had, I mean, today, as it does today, had a fair amount of gun violence. And there was a very restrictive law that was, you know, frankly, in some sense, quite ineffective because it didn't do anything to deter gun violence, right? But under the DC law, you could not possess a handgun in your home. It was illegal to have a handgun in your home in the District of Columbia. It was also illegal to have a shotgun that was kept in operable condition. So it had to be sort of not usable, like trigger locks and you know, or disassembled. It could not be kept in a usable manner. The law had been around since the 1970s, but again, wasn't challenged until the 2000s. And if you have any interest in sort of the history of some of this and history of some of this litigation, I highly recommend this book, which is called Gunfight by Adam Winkler. He's a wonderful scholar at UCLA, and it's a very accessible, interesting book that talks about sort of the history of this litigation and the history of the Heller case in particular. But the Heller case becomes kind of this brainchild of some libertarian activists who teamed up, and lawyers who teamed up with some folks that had a whole lot of money that wanted to finance litigation around the time of the Bush White House, the George W. Bush White House. Some signals that the government was now sort of taking a view that was more favorable to the historical individual rights view than they had historically, and wanting to set up a test case. And they come up with the Heller case as this test case. And interestingly, right, this doesn't actually come from the NRA. The NRA isn't launching this litigation, and the NRA actually tried to shut these folks down. They tried to stop this litigation from happening. And there's some suggestion that maybe they did that because they didn't want the Supreme Court to ultimately rule on the question, even if they were going to rule in the NRA's favor, because there's nothing quite like a sort of a money-making effort for the NRA than saying, you know, they're coming for your guns, they're coming for your guns, right? That gets everyone to give to the NRA. And if the Supreme Court says, actually, you have this constitutional right to individually possess a gun and the government can't take those away, that might hurt the NRA's fundraising efforts. So that's the sort of cynical take on the NRA not actually wanting these sort of rogue libertarian lawyer activists to bring this test case. And they tried to bring their own lawsuit to compete, to sort of take control of the litigation. It's this whole sort of drama that's playing out in this space. But ultimately, they are unsuccessful. They lose on an issue called standing. The NRA's group is unsuccessful in taking over the litigation. They lose on standing, which is this technical requirement to get into federal court. You have to be able to identify an injury. And the only person in the litigation who turned out to have an injury that was legally recognizable was this guy on the screen. This is Dick Heller. He was the only person who attempted to license a handgun in DC and was turned down because, again, it's not lawful to have a gun in your home in DC. And so he couldn't do it. But he had tried and failed. And as a result, that created a legal injury. The rest of the folks just sort of wanted to do it, but hadn't taken the steps because the law forbid them from doing that. So Heller's the guy who gets to be the champion of this cause. He was a, sort of not to offend anyone, but he was an anti-government kind of gun nut. Like he was not your most sympathetic plaintiff. In fact, they had a slate of really sympathetic plaintiffs, including a woman who had been the victim of violence and lived in a neighborhood that was very violent in DC, who had wanted to possess a gun for her own self-defense. And, you know, this is when you're doing this kind of impact litigation, whether you're on the right or the left, getting a good plaintiff that has a story that's very sympathetic is pretty important. And Dick Heller's story was a little less sympathetic. And they sort of had him not talk a lot in the litigation, although he's there before the cameras here. But he is ultimately the namesake of this case. So this case goes up through the federal courts because we're challenging a DC law, and that's a federal law. And as Ellen pointed out, the District of Columbia loses in the DC circuit, which is the intermediate appellate court in between the lower trial courts in the federal system and the Supreme Court. And at that point in time, that was groundbreaking because, again, all of these federal circuits had rejected these kinds of claims based on that old Miller case. But the DC circuit, sort of out of the blue, accepts the individual rights view of the Second Amendment. And while that may seem out of the blue and like a sea change in the law, one of the things that had been happening alongside the sort of litigation trajectory is that starting in sort of the 1980s, the academic literature on the Second Amendment started sort of taking off. This is a space where academics ultimately had a fair amount of influence over how we look at the Second Amendment, for better or worse. And there were some very influential law review articles that were written, including by those on the left, that indicated, based on sort of history and tradition and how the founders had understood the right to keep and bear arms in the Second Amendment, that it did embody an individual right and not this sort of militia limitation. And so that was kind of happening, some of which was sponsored by the NRA, but some of which was serious academic work, including some views from very sort of celebrated left-leaning or quite left law professors at there's a guy, Sandy Levinson, who's at Texas, who's a very well-known liberal constitutional expert, and he agreed and endorsed the individual rights view of the Second Amendment. So all of this was happening around the same time, and the DC Circuit gets the case and they rule for the individual rights view. And the DC law, again, being so restrictive, they strike down the law. And then there was a question about, what does the District of Columbia do? Do they take that case to the Supreme Court or not? They didn't have to. But by taking it to the Supreme Court, there is a circuit split. So there's a disagreement now across the country about what the Second Amendment means. But there was worry that the Supreme Court, which had shifted pretty far to the right by this point in time, would now, change its view of the Second Amendment, and then, sort of abandon Miller and embrace the individual rights view, just like the DC Circuit did. And that is, in fact, what happens. So in 2008, we get the 5-4 decision in the Heller case, where the court holds for the first time that the Second Amendment protects an individual right to possess a firearm unconnected with militia service, right? So now we are settling this question about, what does the militia clause mean? In the home, for traditional lawful purposes. Notice all these caveats. These are all important, right? So in the home, traditional lawful purposes, so we can't use it for unlawful purposes, not criminal purposes, but for self-defense. And that's what the Heller case holds, and it's pretty narrow, and it's important that there are some limits and some caveats. But what is the significant sea change here is that for the first time, the Supreme Court is recognizing that the Second Amendment does protect an individual right, as opposed to this state structural militia right. So it can be used, but there are a lot of, and it can be used by an individual, but there are a lot of unanswered questions about exactly what this means. Let's talk about those, because those are really what's at stake in this new case before the Supreme Court. So the first thing that they didn't do is, the court did not decide a standard for how we decide whether the right has been violated or not. So this matters. It may seem sort of technical, but what the standard is for how we evaluate an infringement of a right is really important, and in fact is often most of the work when we think about constitutional law. That's because no constitutional right is absolute. We use that language a lot. We talk about constitutional rights being absolute. I have the absolute right to do this, right? It's actually not the case. There's no right in the Constitution that's absolute. So think about this, for example, right? The Second Amendment says the right shall not be infringed, which kind of suggests absolute language, right? Shall not be infringed. But the First Amendment, for example, says Congress shall make no law abridging the freedom of speech. Shall make no law also sounds, again, absolute, but that's not the way we've read it. No one really thinks that Congress can make no law abridging the freedom of speech. And in fact, there are times where we've recognized some infringements of various rights of all kinds because they are protecting really important governmental interests, and there's kind of no other way to accomplish it. So there's in normal sort of constitutional adjudication, when we're deciding the scope of rights and what the government can't and can't do, we are often balancing the importance of what the government is trying to accomplish against how it's trying to accomplish it. We call this something like a means ends fit. So is the goal accomplished by trying to infringe as little as possible of this protected right? So if you think about this in the context of, for example, racial discrimination. So this often comes up in like the most probably important modern case that the Supreme Court's going to hear on issues of race discrimination will be a question of affirmative action. And this is a great example where the government, which we've permitted some affirmative action in, for example, like college admissions, where schools, public schools can consider race in admissions. They have to do so in this sort of context sensitive way that doesn't assign particular weights to individuals from different races, but they are allowed in some sense to discriminate on the basis of race, even though normally there's no discrimination tolerated in the law. But they can do this because they are furthering a really important interest, and they're doing so in a narrow, sort of careful way. And that's often the way we think about these constitutional questions. So you can infringe or discriminate, but you have to do so really carefully and narrowly. You have to explain and develop a record that demonstrates why that particular regulation is really important and why it's the narrowest way and the best way to accomplish the goal. So the Heller case doesn't specify how we would decide when the Second Amendment is actually violated. Doesn't give us any of that helpful sort of guardrails or sort of pathways for resolving Second Amendment questions. And the reason is because the law in DC was so obviously unconstitutional if there's an individual right, at least in the view of the majority of the court, that there was really no way to save it, right? If you have an individual right to possess a sort of gun for lawful purposes in the home, then being told you can't have a handgun, which is pretty much the most common form of personal self-defense weapons, like there's kind of no way to find that not a violation of the Second Amendment right. So this was a situation where they didn't have to decide what standard applied, because under any standard in the court's view, the DC law was too restrictive. So we didn't have any kind of gray area that helped the court answer the question about what standard applies. That's not the case in the case before the court now. But the other carve out, the other sort of caveats here is that the court recognized, despite endorsing this individual rights view, it also recognizes that this is not an unlimited right. So just because you have an individual right to keep and bear, to keep an arm in your home for lawful purposes, there are historical limitations on the Second Amendment or on gun rights that have been with us since our founding. And the court didn't want to open all of those up for reexamination, or at least it was trying to say, we're not doing so here. So there's this, like, what I call, when I teach this case to my students, there's like this big caveat paragraph that's just plumped down in the middle of the case where the court's like, okay, these are all the things we are not casting doubt on. So the ability of felons to possess a firearm, for example, right? We're not saying that they have a right to have a gun in the home, or the mentally ill, or, you know, carrying guns in sensitive places like schools or government buildings, right? Importantly, the Supreme Court does not allow you to carry a gun into the court, right? They don't want to start opening that can of worms either, I'm sure. Or laws, and this is important, laws imposing conditions and qualifications on the commercial sale of arms. So our ability to buy certain kinds of arms, to require background checks, et cetera. So the court's saying all of those questions are for another day. And some of those questions are for the day that they had today. The court also clarified that this Second Amendment only applies to weapons that are in common use at the time. And that means common use sort of today, not necessarily like we're not limited to muskets. But it means the Second Amendment doesn't mean that we all have an individual right to like possess a nuclear weapon, right? Or to some kind of strange and particularly dangerous weapon, but common weapons would be the kind that we use for self-defense are the kinds of weapons that the Second Amendment contemplates. So the next gun case, so that was Heller. It was 5-4, there was a dissent. I could talk a lot about the dissent. It was written by my former boss, Justice Stevens. And he essentially just argues with the history of the case, or the history of the Second Amendment, and takes a different view on both emphasizing the militia clause and the language in constitutional provisions like the Vermont one that I highlighted before, that if they wanted to give an individual right, there was certainly a way to do so. and that the framers had other models and they didn't use those models. But he lost. The next important gun case is a case called McDonald against the city of Chicago. And this was 2010, so 2 years after Heller. And this is an important case because it clarifies that the Second Amendment also applies against the states and subdivisions thereof. And that's important because Heller only applied against the federal government. And it is the case that the 10 original sort of amendments in the Bill of Rights all restrict historically just the federal government. We use the 14th Amendment, which comes much later, to what we call incorporate the original rights against the states. It's a complicated doctrine, but basically it means that, like, on their face, the first 10 rights only apply to the federal government. They don't restrict states, but the court decided in this case called McDonald that actually it does apply against the states through the 14th Amendment. And that's important because otherwise then it doesn't have any operation or effect against, you know, all the state and local laws that restrict guns. So Heller, again, only involves the federal government, but here we're applying it to the states. That's potentially not quite as significant as Heller in the sense that a lot of states already had, you know, as I pointed out, like even like that the Vermont language, right? A lot of states had state constitutional or statutory provisions that already protected gun rights. But it's really important in states or cities like Chicago that have pretty restrictive gun rights. And that's what's at issue here in the case, the New York case that's before the court right now. So that brings us to 2010. That was the last time the Supreme Court, as a court in a Merritt's case, had dealt with the Second Amendment. It was silent. So it decides this case that creates, you know, significant waves, very important, overturns a lot of circuit law, and then it didn't do anything for a long time, at least in some people's view. It doesn't, remember, it said that there are all these limits, that we're not going to decide exactly how far it reaches. We're not going to give you a standard lower courts, but we're going to overturn all this law. And then the court didn't do anything for a little more than a decade. And you might say, like, why? You know, why this upheaval and then not do anything? And it suggests there's a little bit of a, you know, lack of desire and appetite problem for sort of engaging in a really difficult question, right? Not just as a matter of constitutional law, but as a matter of policy. You know, guns these are tricky policy, you know, potentially devastating issues. There are 39,000 people in America who die from gun violence annually. That's 100 a day. Now, most of those are suicides, and this is data from the Giffords Law Center to Prevent Gun Violence. But a lot of homicides, and the question of, like, how do we come up with effective gun policy that reduces, you know, gun violence in America is really complicated, and constitutionalizing some of that restricts what states and localities can do in response to gun violence, right? It limits some of the effectiveness of those policy solutions. Because once we say something is a constitutional right, we take certain policy choices that our elected officials might make off the table. But the court was silent about exactly what had been taken off the table. It said you can't go as far as the DC law, right? The DC law went way too far. But there's a whole lot of ground in between a DC law that says you can't even have a gun in your home, right? And a law that says, that limits, you know, that has background checks or limits how you can carry a gun outside of the home. And we don't have any clarity sort of on where exactly that line is in between those extremes. That is until we get to potentially the case the court heard today, and whether the court is going to give us greater clarity on exactly, you know, some contours of this right. So let's talk a little bit about the New York law and why it's important and what the case might do, and then I'd love to open it up to your questions. So the New York law is a case that challenges, it challenges a 108-year-old law, so a very old law in New York that requires anyone who wants to carry a concealed weapon, a concealed handgun outside of the home to have proper cause or a special need to do so. So this is what we would call a may, M-A-Y, carry law, as opposed to a shall carry law. So there are two types of, in general, sort of, when we talk about concealed weapon states, where you have to have a license to possess to carry a concealed handgun outside of the home, there are states that are sort of may carry laws and states that are shall carry laws. So if you're a shall carry, those are states where you basically, as long as you meet whatever requirements the law sets out, which are usually like background checks, and you can't be a felon, right? Is that the state has to issue you, or the locality has to give you a permit. That's the shall part. So as long as you meet whatever those background requirements are, the state has to do that. Those are the shall states. But New York is a may carry state. And it gives discretion to deny those permits or to require proper cause or some special purpose that's beyond the needs that, you and I as just regular citizens would have. So you have to have some some special need that isn't part of the average citizen, like you're potentially threatened by, like let's say you're a big time public figure. So President Trump qualified to have a concealed carry in New York because he was a public figure and, has threats made against him, high profile, and to protect yourself from potential crazies that might make you sort of in a special category where you're entitled to this permit. But not everyone is going to be entitled to carry a concealed gun under a law like New York's. This is similar to laws in California, Hawaii, Maryland, Massachusetts, and New Jersey. And that's a whole lot of people. About 80 million people are covered by these laws. So on its face, whether this kind of may carry a special purpose law is constitutional or not affects a great number of people and their ability to carry a concealed handgun outside of the home. So that's what's at stake. The individuals in this lawsuit lived not in New York City. They lived sort of in rural upstate New York. And they are not, they are, again, sort of selected to be good plaintiffs. So this is not about, although the nature of the law impacts places like New York City too, right? I mean, you think about sort of New York and the diversity within it. There are very different issues at stake in terms of what New York City does in regulating guns versus what somewhere in a more rural part of the state does. So the argument ultimately in the case is about sort of text history. It's about what kind of analogs we draw from historical regulations of guns. And it's about what standard. How do we decide when the right has been infringed? On its face, as a matter of text, if we're going back to sort of the understanding that we get from Heller, the right to keep and to bear arms seems to include something broader than just having a gun in the home, right? Like keeping a gun would seem like just having it in the home, possessing a gun in your home. That sounds like keeping. Bearing sounds like, as a matter of just plain language, right? To bear something sounds like it would include the right to carry or possess it outside of the home for self-defense. So one of the arguments here is that to really give effect to both aspects of the keep and bear, we have to recognize that this right extends beyond just the home, but the ability to kind of use the gun in an ordinary way for self-defense. And so I think there's going to be sort of settled agreement that, now in a post-Heller world, that's what it means. And the state doesn't really disagree with that in theory. There's also an argument that the history of how gun rights have been, or how guns have been regulated in the United States, is consistent with permitting sort of robust concealed carry. robust carrying, I should say, outside of the home. There's some debate because historically, there wasn't a lot of concealed carry. They were mostly sort of open carry as opposed to concealed carry. Most people carried guns quite openly. But that the American colonies in the early states, and sometimes not only like permitted the carrying of guns outside of the home, but actually required it. I mean, there were period of times where individuals were required to have a gun. That was so that they could be called up for militia service. So, looking historically, there's a lot of texture in terms of how gun rights have been, permitted and regulated. And so that's part of this debate. There's a core debate here that the court's going to have to grapple with as to whether the way it answers the Second Amendment question, is it by analogy? Do we need to sort of look back in time and figure out like, okay, is this current law really like that old law, right? Is this consistent with some old law that looks very similar, except sort of, modern language, right? Or are we sort of looking at these questions in a modern context where we're asking like, what is the government trying to accomplish here? What kind of public safety mission is it trying to accomplish? And is it using the best means to accomplish it? And that's part of what's before the court. What standard? How does it decide when something is constitutional for purposes of the Second Amendment? So again, the state, I think its argument is that there is a right to carry a gun outside of the home. It recognizes that there is a difference between keep and bear, and that would include some right to carrying a gun. But that's not an unlimited right, and it's never been unlimited. I mean, even again, if you look at the language of the Second Amendment, a well-regulated militia, meaning the government can regulate. And the state can require, as part of its regulations, a need to have a gun, right? That can be part of, and historically there was a need to have a gun because it was connected to militia service. So just because you have a right doesn't mean, again, that it's an unlimited right, or that you can use a gun everywhere, anywhere, or not be required to make some special showing of the ability to have, or the right to possess the gun outside of the home. The state argues that history is on its side, that there are a lot of laws historically that define and limit the rights of, where and under what circumstances you could possess a gun. I mean, if we think back historically, there were entire groups of people who weren't allowed to possess guns. We did not allow slaves to own guns. There have been all sorts of historical restrictions on gun rights at the local and state levels that are potentially more restrictive than what New York is doing here. So what does all this mean, right? I mean, this is a debate about text. This is a debate about history. It's about how the court decides questions. That will continue. I listened to some of the argument today, and it was some about history, this debate about how do we decide these questions? Are the Supreme Court justices now like historical experts, and all that matters is them combing the historical record to find the best and closest analogies? That is sort of the view of some of the justices. They believe in this mode of interpretation called originalism, where the question is really, how does the public at the time of the Second Amendment, how would they understand what the Second Amendment meant? And would they think that it restricted or somehow made unlawful a law like New York, right? Is the meaning broad enough to protect sort of a more unlimited right to possess a gun in public for self-defense? The other debate here is a bit about like, how do we treat this right? Is the Second Amendment right on par with other rights? And this is a complaint that Justice Thomas in particular, and I think Justice Gorsuch has raised, which is that if it's a constitutional right, it's a constitutional right. There aren't sort of second-class constitutional rights. They're all first order important constitutional rights. And we don't have, for example, you don't have to get a license to exercise other rights. Now, that said, you certainly, if you want to protest in a public park or, organize a public protest, you sometimes do have to get licensed, right? To have a big gathering. So there are some examples of that. But generally speaking, you might see this law, especially a law that says that, you have to meet this higher burden, as suggesting that there's greater room for the government to interfere with this right than we might think of in other spaces, like in the First Amendment context, in the context of religious exercise. And I think, Justice Thomas has made this complaint in a number of cases, including a lot of the cases in between the Heller case in 2008 and a case that the court took in 2019 to decide a similar question, but ultimately rejected. There was that 11-year period where the court, doesn't answer these questions. He's like, why are we dodging these questions? Or we're treating the right as a second-class right because we're not clarifying that it's as important as any other constitutional right. And then I think one of the other things that's really important to pay attention to, in addition to sort of how does the court decide what standard applies, how does it balance the need of the government to ensure safety of its citizens? And there's a lot of debate in the sort of the literature, the medical literature, the public health literature, the policy literature about like what makes for effective gun control laws, and how much leeway it's going to give states to sort of experiment in that sandbox versus, the court sort of doing some tailoring where it recognizes that there are some distinctions that we might draw depending on the nature of the regulation and the location of the regulation. So does it matter whether we're talking about New York City versus Wyoming? How much do local conditions play a part in how calibrated the Second Amendment questions are? And I think that this is where we're likely to see a fair amount of difficulty. Listening in on the argument, there were a lot of questions about like, what do we do about, New York City subways versus, having a gun in a wide open space? What about schools, right? What about bars? The Chief Justice asked, can a city ban firearms in bars? There are a lot of really difficult questions that I'm sure the court will want to probably defer to another day because they're not necessarily this case, but that do become live as soon as the court sets whatever standard it is, because that standard will govern what, how the court thinks about gun rights in other cases. If I had to guess, I think this particular New York law is going to fall. It's quite restrictive in the sense that it allows for, folks who are ordinary citizens not to have the right to self-defense outside of the home because of the restrictions on access to concealed carry guns. And I suspect there will be 6 votes for that position, but or at least 5, and that's all it takes because you only need 5 to win. So if I were to guess, I think it's 6-3 in favor of the folks challenging the New York law, and that the really important sort of and most interesting question will be what exactly the test looks like and how much we're talking about future cases, right? How many other kinds of restrictions? If I were New York, I would go ahead and start passing some laws that identify some sensitive places where guns can be restricted in order to, give greater ability for the state and local governments to, impose some restrictions based on special need in special locations like bars and government buildings and all of those things. So I think that's the end of my slide. So I'm going to stop there, and I'm happy to take your questions or talk. And we can talk about the Second Amendment case. We can talk about whatever's on your mind ish.
Thank you, Merritt. Can you take a look at the chat, or I can read them to you?
Oh, sure. Yeah. So please show the New York law again. Is it the New York I don't know that I showed the New York law. I described it, but it's basically a law that says that you have to have a special purpose to carry a concealed gun outside of the home. So that's the nature of the law. So it gives permission to those who are licensing individuals who want to carry a concealed weapon outside of the home to deny that where there isn't essentially a special purpose.
Okay, thank you. Shirley, go ahead.
Thank you. Merritt, it's so complicated, but
Mhm.
I wonder, do states have what might be considered well-regulated militias at this point in time? And do you think that the January 6th group considered themselves a militia that was trying to protect the government that they thought should exist, even though they seem misguided? Does that give them special exemption to have performed according to the commander-in-chief?
So I am not an expert on, well, I will say this. The militia equivalent today is the National Guard, which is under the control of state governors and can be federalized. So that is the modern day equivalent. In most states, if not all, if I'm not mistaken, outlaw militias outside of the National Guard. So my answer to you would be no. The January 6th folks they cannot be a recognized militia or have any greater rights under the Second Amendment than you or I would just as citizens in our individual rights capacity. So my answer to that would be no.
Got it.
Are there any
Okay.
other questions or comments?
Did we read everything on the chat?
Yeah, there was a question about the book title, but someone answered it.
Yeah, it's called Gunfight, right, by Adam Winkler. It's really good, very accessible. So I highly recommend it.
Yeah, there's been a lot of books written since
Yeah.
on the history of the gun laws and how Heller came about and what it really means and what it doesn't really mean. But the gun law book is a good book.
Rick, I can see you're back. Come on.
Okay, thank you very much. In the spirit of originalism, I'm wondering if you are familiar with whether there was an original text of Madison's Second Amendment before it was debated, and whether that has any play in the way courts have or will be looking at the Second Amendment cases.
So as I recall, there were, so my memory of Heller is that there were two different proposals from different states about how to protect the Second Amendment, and I don't think either. I do not think either one necessarily sheds light on the scope. The best analogies, I think the best. Both had some militia language there, and that really it's comparing it to the sort of absence of kind of self-defense language that's in the other sort of state analogs at the time that is the most powerful evidence of sort of a contrary meaning argument. So there weren't like multiple drafts of this that Madison had, as I recall, in going back to Heller. So I will, I'm tempted to pull up Heller real quick. Let me make sure I don't want to misrepresent that, but that's if you look at sort of the Justice Stevens argument, which relies in dissent on some of the state textual provisions, he's emphasizing largely the state analogs, like the state, state models, if you will, that seem to make much more clear the self-defense requirement or connection with the Second Amendment. And by implication, he's saying the decision not to follow those other models suggests that the militia language was especially important to the framers. Now, that's always, I tell my students that we have to be really careful when sort of making decisions by implication, like the failure to do something sort of implies that you're endorsing something. So I think, I think that's tricky, as much as sympathetic as I am to Justice Stevens' view. So I just want to make sure, but I could go ahead and I will look at that while I get another question. Or if was there a question in the chat?
It was a compliment.
Oh, okay.
Rick, you made her pull out the big book. Any other questions?
There is a question in the
There
chat.
is. How do you think the court will demonstrate the nonpartisan posture it claims to have?
We leave it to Judge Stevens.
Sorry, what?
We leave it to Judge, I'm sorry, to Justice Roberts to do that.
Yeah.
That's
So-
who everybody is making their pitch to.
They are, although he's not going to be the swing vote. I mean, it's potentially like a Kavanaugh. The court, I suspect, so I think the way the court looks at these things is that it does so not maybe necessarily in an individual case. So like demonstrating nonpartisanship in an individual case is really tricky, but that over the sort of course of a term, you're going to see some surprises. So when I was here with you last year, I talked about the Title VII cases, the employment discrimination cases, where we recognized, the court recognized that sexual orientation and transgender individuals were protected by Title VII, which surprised a lot of folks and seemed like a quote unquote liberal view, right? That was adopted by a conservative court. And I think the court sometimes, and Chief Justice Roberts in particular, might look for cases where you can have outcomes that seem quote unquote liberal, that is a way to sort of balance out other decisions that may come off with more of a partisan valence. So think of what Ellen started with by talking about the court's decision in the Texas abortion case, where I suspect they will find, as Ellen suggested, that at least the abortion providers have the ability to bring a suit. That will be seen as kind of a liberal outcome, right? Despite the fact that they are a conservative court. And so I think that the way the court does this is it kind of works out in the wash, right? Whereas some individual cases, I don't expect, I suspect this will have a partisan split. This is very likely to be a 6-3 or, maybe 5-4, but I suspect it'll be more likely to be 6-3. But we're probably going to be surprised by some other case, this term where there are unlikely alliances or unlikely results, and that the way the Chief Justice manages some of the sort of court legitimacy concerns, or the public view of the court is in sort of taking a long view that on balance, he doesn't want the court to be seen as overly political in too many cases. That's sort of how I see him managing it. But that's just my prediction. He doesn't have to follow it. And so I'm not entirely sure that's right. And I was looking back at my example of from Heller, but there were different proposals that were sent by like the state of Virginia and the state of North Carolina had sent some different proposals. But I don't think, at least they're all ones that that the Chief Justice, the Justice Scalia, who wrote Heller, is relying on at time. Well, actually, no, Justice Stevens was relying on some of them. And they all, at least some of them, sort of use that they have the keep and bear. The one example is that New Hampshire, in particular, wanted a language that would have been more direct. So New Hampshire's proposal for the Second Amendment was that Congress shall never disarm any citizen unless such as are or have been in actual rebellion. So that's an example of language more like the Vermont language that was proposed, so Stevens is suggesting that by not picking the New Hampshire language, but going with the language that Virginia had proposed, which does have that militia language. It gets shortened a bit in the drafting. It's quite long, but it gets he makes some hay of that in his decision. Again, where this is sort of the decision to go with one over the other. We're suggesting that that has real weight. I see Tom's hand is up.
Tom, if you'll unmute.
How long has it been since the Supreme Court numbers of the justices were increased? And what is the mechanism for doing that?
So the number of justices on the court is not set by the Constitution. So there's no provision in the Constitution that specifies how many justices. The Constitution requires a Supreme Court. That's the only, in fact, federal court that's required by the Constitution. Congress shall create a Supreme Court in the language of the Constitution. The court packing efforts were last present, but failed in Franklin Delano Roosevelt's era in response to some hostile decisions from the New Deal. Before then, I think it was like at least back into the sort of around-ish the Civil War, post-Civil War time, there was some change. The court has been like, it's gone from like initially it was 5, and then it was 7, and then it was 9. I think there might have been 10 for a while, and it went back to 9. I mean, there was a fair amount of movement in terms of and some manipulation. I mean, one of the early famous cases is an effort by the anti-federalists who lost early on or the Federalists who lost to the anti-federalists. So when Adams lost to Jefferson, to sort of pack the courts and limit terms and do all sorts of manipulations to kind of preserve federal power for a while, Federalist power for a while. So, the history of using the court in some ways is present. It's not a historical anomaly. One might say that sometimes even the discussion, like arguably that Roosevelt's effort to court pack, even though they failed on the ground, was successful because the court moved. The court was striking down all the New Deal era legislation. And then there was what we call the switch in time, a vote switch that saved the 9, so that there was a justice who changed his views. Incidentally, his name was Roberts, and he switched his vote. And as a result of that, the court packing efforts kind of died down, but the court ultimately kind of acquiesced in its views of the Constitution in ways that favored Roosevelt's legislation. So, the fact that like court packing is like a topic, I mean, we have a presidential commission that's reviewing court packing right now. Some scholars think, well, at the very least, the conversation might have a moderating effect on the Supreme Court. And even if, no justices get added, that just having the conversation might encourage the court to be more moderate, right? And I especially think that's something that, could play out in response to the abortion case. So the Hobbs case, the Mississippi case that will be argued, not the Texas law. But if Roe v. Wade gets overturned, I think the calls on the left to do something with the court will become very intense. Now, we had an election yesterday in Virginia, right? That did not go the Democrats' way, and that signals that they're likely to have real problems at the midterms in 2022. And politically, if Congress can't even right now pass an infrastructure bill and the reconciliation plan, the Build Back Better plan, I certainly don't see them modifying the number of justices on the court anytime soon. There's not going to be agreement to do that. So, I think court packing is ultimately not possible. But the conversation at least maybe has some effects on the court potentially. I don't know. It's hard to measure. It's hard to know. But it's, it certainly went from a fringe idea to being something that folks talk about, and that has its own power.
Well, this has been another great program. Ellen, I don't see any other questions on our end. Any final comments?
Merritt, thank you so much. As always, your presentation was wonderful.
Well, thank you.
For all the rest of you, I would have to say this is a very, very complex subject. As Merritt referenced, there are a lot of competing issues and interests at stake. Some are local. A lot of them are local now because they've had more success with arguing local effects of the laws rather than the general overall effects of the law. I just want you to remember that the lawmakers who are passing these laws are all protected because there are no guns permitted on the Hill. So the federal oversight of the Hill is not an issue. They all are absolutely protected because there are no guns permitted on the Hill except for emergent circumstances. Some lawmakers have them, but most of them do not, and they certainly aren't permitted in the chambers where the laws are passed. And the other thing I just wanted to say is DC especially has been a hotbed for these gun laws because of the amount of tourists that come through the Capitol, the amount of tourists that come through DC, the subway system like New York, and the fact that there are other protected federal domains within the district which have to be treated differently than property owned by the District of Columbia. So the district itself is not a great example of how the gun law should be enacted or how they should be implemented. So just keep that in mind as we move through these cases. I hope you've all enjoyed this course. We probably will end up doing it again next year if I can corral my presenters to come back. We're going to have a very interesting term. Watch it closely. And if you have any questions, please feel free to contact me or any one of the presenters. I know they'd be glad to answer your questions. And with that, I wish you all a good afternoon.
Thank you so much. It was a lot of fun.
Thank you again.
Bye-bye.